Sorry for the delay, first of all. And you know that when it is a speaker like K. Prabhakar, an advocate from Madurai High Court, then you would know that the wait is worth that because his knowledge on different perspectives of law we have already seen. Today's session is charge on immovable property and its priority. The Transfer of Property Act 1882 has its own impact on this particular aspect. I'll not take much time because we have already delayed the session. Over to you, Mr. Prabhakar, and thank you for your patience.
Thank you, Vikas. Good evening, my friends. Section 100 speaks about a charge on an immovable property of one person by an act of parties or operation of law made security for the due payment of money to the another. And if the transaction does not amount to a mortgage, the latter person is said to have a charge on the property, and all the provisions which apply to a mortgage will apply to a charge. There are two things under section 100. One is it's an operation by law or by act of parties. Before we dwell into the other aspects with regard to charge, one has to concentrate on these two aspects. What is an act of parties and what is an operation of law? You may know that act of parties means it's an invitum, namely, there should be maybe a contract between the parties which creates a charge, and under section 100, a contract can create a charge, and this contract should be valid and enforceable. And the operation of law means by a particular provision in the law, automatically charge will be created. How this charge is created by act of parties and operation of law. One can say the act of parties, namely, a charge is created in favor of a wife or a widow for a maintenance. A widow is entitled to a maintenance, and this is by operation of law, this can become available to her in respect of the properties. Whereas in case of an agreement between the parties for a sale of the property, whether in case of an unpaid seller or in case of a purchaser where the specific performance of contract fails and he avails of the alternative relief of a refund of money, he is entitled to a charge on the property. Then there are other aspects which also comes into play, namely the priority. Namely, if a charge has been created and if a person who doesn't have the notice of the charge and purchase a property for a valuable consideration, which is an exception under the Act, then he becomes a bona fide purchaser where the charge cannot be enforced. The second exception is that in case of a trust property where the trustee spends money for the performance of the obligations under the trust, and he has to recover the property from the trust for the obligations performed by him, then that the charge will not get attracted. Namely, he will have the right to take that money before ever the charge kicks in respect of the obligations of the trust to a third party. The two exceptions, therefore, are a trustee who performs his obligations under the trust, where he spends money and he has to recover the money from the trust, then it will have a priority. Then the second exception is that in case of a purchaser who doesn't have a notice of the charge, when he will have no notice of the charge, if it is a registered document, then there will be a constructive notice, and if there is a possession not available with him at the time of purchase, somebody else is in possession of the property, then the party can be called as a person who has a notice of charge, namely, if there is a registered document, or in case where the possession is with the third party, then he cannot be called as a bona fide purchaser. And then the question of notice of property being purchased by him without notice does not arise. These are the two exceptions contemplated under section 100. But the section 100 speaks about equating this charge with a mortgage. But there are subtle differences. A mortgage creates an interest in the immovable property. But all mortgages are charged, but all charges are not mortgage. Therefore, in applying the principles in respect of a charge, one can take inspiration from the provisions of the Transfer of Property Act, namely the provisions with regard to the mortgage. What are the provisions which will have an impact on charge, which have an impact on mortgage? I can cite some of them. Section 56 of the Transfer of Property Act, namely marshalling. 67, foreclosure or sale. 68, right to sue for mortgage money. 79, securing amount which is stated to be uncertain. 83, depositing money into court, namely the mortgage money. 92, subrogation. I'll deal with one after another. What is marshalling? Marshalling means that mortgage can be created subsequently one after the another. Once mortgages are created one after another, the prior mortgage will have a preference over the subsequent mortgage, unless there are some exceptions covered under the Act. The foreclosure or sale, where a property can be brought for sale or where the property can be redeemed in a mortgage. These will also apply to a charge, where the conditions embodied in the charge get discharged on one account or the other. Then the property can be completely made freehold or free of the charge. Then right to deposit the mortgage money. A money due under the mortgage, a person who has got an interest in the property can deposit the money to redeem the property. He can deposit the money in court. Similarly, even in case of a charge, this can be done. Now, subrogation. Subrogation means one after the substitution of one with the other. This is possible under mortgage. It is also equally possible under charge. But there is a difference between mortgage and a charge. Even though the provisions contemplated under section 56, 67, 68, 79, 83, and 92 of the Transfer of Property Act are applicable to a charge is not a mortgage, because section 100 itself speaks that it is not a mortgage. Therefore, some of the cases, an interesting point arose whether to create a charge by act of parties. I'm not talking about operation of law. The first part is act of parties. When act of parties contemplate is a contract. In case of a mortgage, it requires a registration if the value of the property is more than 100 rupees, and it has to be attested by two witnesses. And then only the mortgage is, as defined under the law, gets fulfilled. But whether a charge which is equated with a mortgage under section 100 requires registration for enforceability and requires attestation by two witnesses, which is mandatory in case of a mortgage, or whether it is a simple mortgage or a superficial mortgage, etc. There is quite a lot of decision on that aspect, but ultimately it was settled that a charge, what has been contemplated under section 100 consists of two legs. One is it is equated with a mortgage in certain extent, but the charge is not a mortgage. Therefore, once a charge is created, then the provisions of mortgage will apply. But to create a charge, it cannot be equated with a mortgage. I'll give you a subtle difference between the two. If you want to create a mortgage, you go and if it is more than 100 rupees value, you go and register a mortgage, and the mortgage requires two attesting witnesses to do that. If it is done, the mortgage deed has been duly executed and attested in accordance with the law. But in case of a charge, how to create a charge? Except section 100, there is no provision under law how to create a charge. Therefore, the law originally it was, or interpreted originally, it is in both the limbs to create a charge and to apply or enforce the charge. Both of them, as it has to be treated as a mortgage. But subsequently, it has been clarified by the Honorable Supreme Court that for creating a charge, there is no form necessary, and therefore the definition of a mortgage, namely it should be by a registered document and to be attested by two witnesses, does not apply to a charge. Very interestingly, one case came up before the Honorable Madras High Court, namely Venkata Shastri versus Abdul Jabbar Sahib. Venkata Shastri versus Abdul Jabbar Sahib. We have 5 judges of the Madras High Court. Reported in 1962, one MLJ, wherein the Lordship came to a conclusion that the charge, if it is to be enforceable under law, it has to be created as a mortgage. And in that case, there was only one attesting witness. And it was also argued before the court that a sub-registrar or the scribe can also be called as an attesting witness. The court found on facts that neither the sub-registrar nor the scribe on facts can be called as a attesting witness, because they have done an official duty, namely the sub-registrar, and the scribe is only a draftsman. It came to a conclusion that the charge has got only one attesting witness. Therefore, no valid charge has been created. This was a decision of 5 judges. The matter went to the Supreme Court. In Abdul Jabbar Sahib versus Venkata Shastri, AIR 1969, Supreme Court, page 1147. In that, the detailed analysis by the Honorable Supreme Court subsequently came to a conclusion that the charge contemplated under section 100 has got 2 limbs. One is creation of a charge, and 2, enforceability of a charge. For creating a charge, the definition of a mortgage or what is mandatory for executing and registering a mortgage, it does not apply. But in case of enforceability of a charge, the provisions of mortgage can be applied. How this was done is by interpreting the language used in section 100 itself. What it says is this: where immovable property of one person is by act of parties or by operation of law made a security for the payment of money to another, and the transaction does not amount to mortgage, the later person is said to have a charge on the property, and all the provisions herein before contained, which apply to simple mortgage, shall so far as may be applied to such a charge. What they have interpreted is the later person is said to have a mortgage charge on the property and all the provisions herein before. This the Honorable Supreme Court interpreted that the mandate with regard to mortgage will kick in only after the execution of the charge or creation of the charge, and therefore for creation of a charge we can't equate the mortgage, no attestation is required, and therefore on facts, when one attesting witness is found, the charge created is valid, and it has differed from the 5 judges of the Honorable Madras High Court and gave a finding that only in respect of enforcing a mortgage, enforcing a charge, the provisions of a mortgage will apply and not for creating a charge. Now, coming to the second aspect, where all we will be using this charge, one is with regard to the maintenance, second with regard to the agreement of sale, three, unpaid seller are refunded by the purchaser of the advance paid and the other acts. Now, coming to the first is the maintenance. The maintenance is always created by the lady may have the widow or a wife may have a pre-existing right of maintenance in respect of a property of her husband, or even in respect of a joint family property. She can claim maintenance. Therefore, once a widow comes to a court or a wife comes to a court for a charge on the property, she has a pre-existing right. If she has got a pre-existing right of maintenance, then the the charge created is not new, or a degree which passes on the basis of a claim made by the wife or the widow does not require anything, and it is enforceable. On the other hand, if a degree for the first time creates a charge for the first time without any pre-existing right, suppose in a compromise, a party is given that he is entitled to a money from the other party, and in case of the money is not paid, he can go after the person or the property contemplated under the degree or a compromise degree. Then the law says that such a such a degree by itself will not create a charge. The difference is, if a degree is passed on the basis of a pre-existing right, then the charge does not require any registration. On the other hand, if the charge is created for the first time under the compromise or a degree, it is invalid in the eyes of law. Namely, even if it is registered, the reason is charge contemplated under section 100 is by act of parties or by operation of law. Earlier, some of the judgments, I think if I remember 1936, how, where a degree passed by the court was tantamount to a charge created by operation of law. But this was not subsequently followed by any of the courts. There were a lot of rulings on that aspect, whether if a degree creates a charge or whether it is a valid charge enforceable in the eyes of law. Some of the judgments would show that it is valid, but later point of time, very many high courts, namely full benches of the high courts, I'll come there. Full benches of the high court has differed from the view of the House High Court and holding that if a charge is created under a degree, it is not an enforceable charge because it is not a charge by act of parties or by operation of law unless the parties therein have got a pre-existing right. You are aware of the fact that a compromise is only a contract. Therefore, if and the authentication is made by the court. Therefore, unless there is a pre-existing right, it is not enforceable. The first point is with regard to the widow. I can cite the decision reported in AAR 1928 Madras 713, a full bench judgment reported in Raja Timmanayanam Bahadur versus Raja Damara Kumara Venkadappa Nayanam Bahadur. AAR 1928 Madras page 713. It was a case of a compromise degree where the lady was entitled to maintenance that was accorded in the compromise degree in respect of a partition. Whether this is enforceable in the eyes of law, whether this charge created will have a priority over other names. The court has held that the lady has got a pre-existing right of maintenance that is amplified in the compromise degree, and therefore, once a charge is created, that will relate back to the date of the suit. And if there is any transaction subsequent to the date of the suit, it is affected by lis pendens, then also the lady will have a first charge of the property. The second decision is AAR 1959, Andhra Pradesh, page 622. AAR 1959, Andhra Pradesh, page 622. Sri Raja Bommadevara Viranga, Venkata Narasimha Rao versus Sri Raja Janardana Krishna Ranga Rao. AAR 1959, Andhra Pradesh, page 622. This was a case of a full bench where the subsequent decision, the earlier decision of the Madras High Court, even that of the full bench, have all been considered. And the court ultimately answered the reference on the ground that Section 100 does not contemplate a charge provided by a degree. It was not a case of a pre-existing right like that of a widow, which I was stating in respect of AIR 1928 Madras. Therefore, if a charge is created for the first time under a degree, whether it is a compromise degree or a degree by court, this degree is unenforceable because the compromise can at least be called as an act of party, but a degree is neither by act of parties nor by operation of law. The first judgment which I was citing, namely in IAR 1936 out, was a judgment where the court, without any discussion of the legal position, found that the operation of law is includes a degree by a court, stating operation of law means enforcing the law. Enforcing the law means only through court. Only through court means by either an order or a degree. But this view was not acceptable to any of the subsequent judgments. Therefore, they have differed. I think the decision AIR 1959 Andhra Pradesh, page 622, holds the field as of today. The next point is, if a person has got a notice of charge or not, because the exception says that a person who purchased the property without knowing the charge can be called as a bona fide purchaser, and he can come within the definition of escaping from the charge. But in practicality, is it possible? What happened in one case, Dattaraya Shankar Mote versus Anand Chittaman Dattar, 1975, 2 SEC, page 799. 799. In that judgment, the property which was not the subject matter of the suit originally was subsequently made part of a compromise degree. Is this possible under law? That a property which was not the subject matter of a suit can be subsequently brought by way of in a compromise. The issue was, between the date of the suit and the compromise, there was a transaction. A compromise degree gives a charge on the property, but the person who purchased the property contended that this charge will not operate from the date of the suit, because on the date of the suit, this property was not in existence in the suit, rather, because it was subsequently added during the compromise. Between the date of the filing of the suit and the compromise, I have purchased the property. Therefore, the question of lis pendens does not arise. Lis pendens, as contemplated under Section 52, says that the property should be directly and specifically an issue in the suit. And also says that a person who is a bona fide purchaser can defend his title, stating that he is a bona fide purchaser. You are all aware that a bona fide purchaser, how to prove he is a bona fide purchaser? He has to get into the box and state that I have no knowledge about the earlier transaction. That's enough. The burden of proof. In case of a person who states that he is a bona fide purchaser is very, very, very light. And therefore, the court in Dattaraya Shankar Mote's case came to the conclusion that he is a bona fide purchaser without notice of charge, even otherwise, because it was not included or incorporated in the plaint at the time of filing of the suit, it will not have any impact. Therefore, even though the property was purchased by a person after the filing of the suit, given the factual backdrop, the person who had purchased the property is a bona fide purchaser, and therefore that property cannot be liable for any charge made under a compromise. The next case was and whether an undertaking given can be construed as a charge. Normally, there will be an attachment, there will be an injunction by the court, and there also be an undertaking. In many a case before the trial courts, we don't know the distinction between injunction, attachment, and an undertaking. Once an undertaking is given by the defendant or the respondent, the court will close the application in respect of attachment and move on. But there is a real and present danger of such a act by the court, and the parties and the advocate should be vigilant that at no point of time an undertaking can be equated with an attachment. The reason is an undertaking given by a person and violated, then he can be hauled up for civil disobedience, namely not obeying the order of the court. But what about the purchaser who has purchased the property because there was only an undertaking? Once there is an attachment, then any person who purchased the property is subject to, his right is subjected to the attachment. But in case of an undertaking before the court, such an undertaking does not create any interest. It is only a personal bond. A personal bond can be enforced against that person alone and not against the person who has purchased the property. He can always plead and prove that he was a bona fide purchaser for a valuable consideration, and the charge will not get affected. And this was rightly amplified by the Honorable Supreme Court in Haryana Financial Corporation versus Gurucharan Singh. Haryana Financial Corporation versus Gurucharan Singh, 2014, 16 SEC page 722. 2014, 16 SEC page 722, where an undertaking was given before the court that he will not alienate the property. Violating the undertaking, a transfer was made. And subsequently, when the charge was created, the question arose whether the charge will relate back to the date of the suit, and if it relates back to the state of the suit, whether the undertaking will have an effect equivalent to that of a charge. The court has held that it is not possible. A charge cannot be created by an undertaking, and therefore it is unenforceable in the eyes of law. Why an undertaking is not a charge? Now go to the definition. The definition says it should be either by act of parties or by operation of law. Act of parties means the two parties should come together and thus execute or draw up a memorandum or a contract or an agreement. If one party gives to the court an undertaking that I will not sell the property, there is no contract. It is not an act of parties, but a unilateral act done by one party to the court. We cannot equate the relationship between the court and the party and reducing it to the contract between the court and the party. Therefore, once an undertaking is given, this cannot be called as a contract or an act of parties, and therefore no charge will be created by a mere undertaking that is a authorities or a financial corporation's case. The next case is Bank of India versus Abhay Narattam. Bank of India versus Abhay Narattam, 2005, 11 SEC page 520. 2005, 11 SEC page 520. Whether an agreement will create a charge. A mere agreement may not create a charge. Suppose that was a case where an agreement was entered into by a owner of the property and a builder. And subsequently, the builder, on the strength of the MOU with the owner or contract with the owner, borrowed money. And subsequently, the bank thought that they have got a charge on the property. When the builder defaulted, they, on the basis of the MOU made between the owner and the builder, the bank thought that a charge has been created on the property and therefore went after the property. The court held that an agreement will not create any charge. A mere agreement will not create a charge. You can go and see section 54 of the Transfer of Property Act. Section 54 speaks about the sale and how a sale has to be made. And last line would say, an agreement of sale by itself does not create any interest. The wording is by itself. What is that by itself? Stand alone. An agreement of sale by itself means by taking the agreement of sale alone, it will not create any interest. That was the decision of the Supreme Court in Bank of India versus Abhay Narattam, where the court said there was a MOU between the builder and the owner of the property. There was only an agreement to construct the property, and therefore it will not create any charge. The bank, on the basis of the MOU, having advanced the money, cannot recover the money on the basis of or going after the property of the owner. Of course, the builder will be personally liable, or it can go after some other absolute property of the builder, but that property over which the constructions were made by the builder cannot be made liable, as no charge could be created. Even if created, it is unenforceable in the eyes of law. But there is some distinction which the Supreme Court also considered in that case, that if agreement of sale is coupled with the possession, will the charge be created or not? A nebulous position where section 54 says an agreement of sale by itself does not create any interest. Can an agreement of sale coupled with possession or delivery of possession would create a charge on the property or create an interest in the property whereby a person can go after that property as though there is a charge on the property? Not many judgments are there on that aspect, but to my mind, two judgments comes. One is Amulya Gopal Mamudar versus United Industrial Bank. Amulya Gopal Mamudar versus United Industrial Bank, AAR 1981, Calcutta, page 104. AAR 1981, Calcutta, page 104. Again, another decision, which is a bit earlier to the decision, is Usha Rice Mill Company Limited versus Union Bank of India. Usha Rice Mill Limited versus United Bank of India, 1977, ILR, Calcutta, page 385. ILR 1977, Calcutta, page 385. This ILR 75, page 385, Usha Rice Mill case was a single judge. Subsequently, there was also a division bench, namely Amulya Gopal Mamudar case. In that case, both the cases are to the fact that an agreement of sale was entered into and possession was delivered. it was contended that a mere agreement of sale does not create any interest, and therefore it will not create a charge. The court accepted that legal position. But on facts, it was found possession was given to the party, and this person, on the basis of or on the strength of possession, enjoyed the property. We can say that a person under an agreement of sale owned, possessed, and enjoyed the property. These three things combined together, owning, possessing, and enjoying the property combined together, what will be the status? If not an absolute title, it will give you a possessory right to the property. Section 54 merely contemplates how a sale has to be brought out. Namely, if it is rupees 100 rupees and more, there should be a consideration either paid or promised, or partly paid or partly promised. And if it is 100 rupees or more, it is to be by way of a registered document. In case of a sale, attestation is not required. That is the definition of section 54. But a possessory right is a common law principle that is not contemplated as section 54. Therefore, the court took into account that it is not a case of a mere agreement of sale. If it is so, no charge can be created. But once this party entered possession of the property, dealt with the property as though his property, put up construction or made improvements to the property, then it can, in law, it can be construed that this man has got a possessory right. Whether this possessory right can be made as a charge on the property or not, the court held that it can be. This judgment was brought to the notice of the Honorable Supreme Court in Bank of India versus Abe Narottam. But the court did not follow that for the reason, not on legal plane, but on the reason that it was only a construction agreement between the owner and the builder of the property, where no legal possession or exclusive possession was delivered. You know, when a contract is made between the builder and the owner of the property, the builder will have a right to enter the property to put up construction. That's all. It is not an exclusive possession or excluding the original owner of his possession of the property. It is more of a joint venture between the builder and the owner of the property. And therefore, in such a scenario alone, the court held that the agreement of sale by itself cannot create any charge on the property. But an agreement of sale coupled with the possession, and if this possession as elevated to that of a possessory right to a party, that possessory right can be matter of subject to a charge on the property. The next case is the state of Karnataka versus Shreyas Papers Limited, AAR 2006, Supreme Court, page 565. AAR 2006, Supreme Court, page 565. How to prove a charge? Namely, it is not a proving of the charge whether it has been validly created or not. That is the fundamental question. The charge created must be to the notice of the person to say that you are not a bona fide purchaser and you are only a subject, your right is subject to that of a charge, for which the party has to establish that a person who has purchased the property had notice of a charge on the property. When it will, the actual purchaser, if he has no notice, and if he is not covered under section 52 of the Transfer of Property Act, then he can be called as a person, bona fide purchaser, who purchased the property without any notice of charge. This notice of charge is contemplated under section 100 also. Under section 52, lispendence contemplates a bona fide purchaser But the law has taken a different view. When the cases have come up by a widow or a wife seeking maintenance of the maintenance, where the court has held that the section 52 will have a overriding effect over section 100. Section 100 independently speaks about a bona fide purchaser. Section 100 is a special provision in respect of a charge, whereas section 52 is a general provision. Whether a special provision will have an overriding effect over a general provision or the converse. Normally, the general provision will not have an overriding effect over a special provision. The special provision will have an overriding effect on over the general provision. But in case of a charge, the court has held that even though the charge has been spoken to under section 100 and also spoken to under section 52, once this charge is once the sale is affected by dispendence, then there is no escape. But that is a settled position. Therefore, one has to take that this bona fide purchaser without notice of charge will come into play only in cases where there is no suit is pending or before the filing of the suit. Once he purchased the property after the filing of the suit, all his rights are subject to section 52, and therefore he cannot be called as a bona fide purchaser for value. The next judgment is Delhi Development Authority versus Skipper Construction Company Private Limited. Delhi Development Authority versus Skipper Construction Company Private Limited, AAR 2000, Supreme Court, page 573. AAR 2000, AAR Supreme Court, page 573. This was a case of an agreement of sale. Once there is an agreement of sale, and the court believes that the agreement is true and valid, but refuses to enforce for the specific performance of a contract on some other ground which is contemplated under the original section 20, which is not available as of today, after the amendment of the Specific Relief Act, namely hardship, unfair advantage, etc. The court feels that the specific performance is not grantable. The court finds that the agreement is true, then it will order refund, provided it has been sought for as an alternative relief. Do remember, if an alternative relief has not been sought for, the courts are not supposed to grant a relief because there is a specific mandate that for a refund of money, there should be a prayer specifically. But coming to the case on hand, an agreement of sale, a party files a suit and get a degree for refund. Once a refund of the money has been ordered, the charge will be automatic under section 55 of the Transfer of Property Act. Once a charge is created, there is no escape to pay the money to free the charge of in respect of the property. But there is one exception. The charge cannot be created unless the buyer improperly declined to accept the delivery of property. There are two provisions under section 55 of the Transfer of Property Act. I will take 55(6)(b). The buyer is entitled, unless he has improperly declined to accept the delivery of the property, to a charge on the property as against the seller and all persons claiming under him, to the extent of the seller's interest in the property for the amount of any purchase money properly paid by the buyer in anticipation of the delivery and for interest on such amount. And when he properly declines to accept the delivery and also for the earnest money awarded to him of a suit to compel specific performance of the contract or to obtain a degree for rescission. Therefore, In case of an agreement of sale, unless and until the buyer improperly declined to accept delivery, a charge will be automatic. What is that improperly accepting the delivery? Suppose after the contract was executed, and if the seller is entitled to sell, is interested in selling the property, and the buyer is not interested in purchasing property at that point of time, if he declines, these are all facts to be proved in each case. A buyer declining to purchase the property is not easy to prove. But on facts, if a seller comes and say that I am prepared to sell the property by executing the sale deed in pursuance of the agreement of sale, and the buyer dodges or while away his time, is not interested in purchasing the property immediately, the seller can cite this section 55(6)(b), stating that he has improperly declined to take delivery of the property, and therefore I am not liable for any charge. This is an exception to the main rule, and it has found mentioned in the judgment reported in Delhi Development Authority AR 2000 Supreme Court. The unpaid seller. Who is an unpaid seller? The earlier case which we have dealt with is the buyer who got a degree for alternative relief of a refund of the money which he has paid as an advance, and when the court is not inclined to grant a degree for specific performance, there was a refund in case of a buyer. Who is an unpaid seller? Unpaid seller is a person where the sale deed was executed and the money under the contract or the sale was not paid. He becomes an unpaid seller. Why it can happen and how it can happen? Kindly turn to section 54 of the Transfer of Property Act, which defines a sale. A sale is a person offering the property and another accepting the same for a price to be paid or promised, or partly paid and partly promised. What is that meaning? For a sale deed can be executed for a price receiving the money on the day or earlier, or for a price promised to be paid in future. I will get the property today. I will pay you the entire consideration, sale consideration, after 1 year. This is also a valid sale. Don't think that before the sale deed was executed, the entire money has to be paid. It can be paid or promised. It can also be partly paid and partly promised. Suppose I want to purchase the property for 1 crore. I paid 50 crores and got the sale deed executed and stated in the sale deed itself that the remaining balance of 50 lakhs will be paid in future. This is partly paid and partly promised. In such cases where there was a promise to pay the money in future, or where there was a promise to pay the balance consideration in future, and if that money has not been paid by the buyer, what is the remedy available for a seller? You cannot cancel the sale because the contract is executed with an intention you will recover the money in future. Therefore, once such a clause has been found in the sale deed, namely for a price to be paid in future or promised to be paid in future, or partly to be paid and partly promised to be paid in future, then the right of the seller is that of an unpaid seller. His money has not been paid. What he has to do? He has to file a suit for recovery of money. In such cases, so long as the money to the seller has been settled, there will be a charge on the property. This is called as an unpaid seller. The decision on that point can be referred to as Vidyadhar versus Manik Rao, AIM 1999, Supreme Court, page 1441. Vidyadhar versus Manik Rao, AR 1999, Supreme Court, page 1441. yes, sale will be complete. No doubt there will be a transfer of property, and the buyer is entitled to have the property. But so long as the money has not been paid or remained to be paid to the seller, there will be a charge on the property, and the seller can go after the property, bring the property for sale, for discharging the dues under the sale deed. The second judgment is Illegal Joseph versus Cholapura Viranda Devi. Illegal Joseph versus Cholapura Viranda Devi, AAR 2009, Kerala, page 2. An interesting judgment. It was a case where the charge was created under section 55(6) subclause B. Namely, it was argued that on two grounds there was a improper decline to take delivery by the purchaser, and therefore there is no charge available. And second, it was also contended that the the suit is barred by limitation because you have to come within 3 years. It has been settled, in fact, even before that also, that in case of a charge on the property created under section 100 in respect of an immovable property, the limitation is 12 years and not 3 years. This is the overall picture of section 100, and coupled with the section 52 and 55. And as I have stated, that some of the provisions of mortgage will also apply. But do remember that charge and mortgage are fundamentally different on two aspects. One, with regard how to brought out a charge. It does not require a registration or an attesting witness in case of a mortgage. And two, the charge will be applicable in cases where it is created either by act of parties or by operation of law. This priority comes under the Transfer of Property Act. Now we will go into the other acts under which this priority of a charge has been discussed. I will run through one or two judgments. I will try to close today. One is State Bank of Bikaner and Jaipur versus National Iron and Steel Rolling Corporation. State Bank of Bikaner and Jaipur versus National Iron and Steel Corporation, Rolling Corporation, 1995, 2 SEC, page 19. 1995, 2 SEC, page 19. It was a case of a creation of a charge raised by a commercial tax office over the bank mortgage. The property was mortgaged with the bank. Subsequently, the commercial department came out with a claim that the person who was the owner of the property was commercial tax liability, and for which there is a charge. This charge is by operation of law, and therefore they are entitled to recover the money first. It was the case of the bank that a mortgage has been created without any notice of discharge. Normally, in case of a buyer in respect of an immovable property, he has to prove that he has purchased the property without a notice of charge. In the case on hand, a commercial tax due, which is due to the government or the sovereign, will have a priority over any debt, including that of a bank mortgage. Even if this charge created by the Department of Commerce with regard to commercial taxes is subsequent to the mortgage, being a sovereign debt, it will take a priority over the bank, even the bank mortgage. The second is another interesting judgment. Employees Provident Fund Commissioner versus official liquidator of SK Pharmaceuticals. Employees Provident Fund Commissioner versus official liquidator of SK Pharmaceuticals Limited. AAR 2012 Supreme Court, page 11. AAR 2012 Supreme Court, page 11. The EPF, or the Employee Provident Fund, as a specific provision or a special provision which says that it has got a priority over all the creditors. The what happened in that case was the property was under the liquidation, and the liquidator of a particular company called SK Pharmaceuticals claimed that under section 529 of the subclass 1 of the Companies Act, they have got a right or a priority over that of the commercial taxes. The official liquidator is not acting on behalf of the government. He is on behalf of all the creditors. Therefore, the court has held that the EPF has got a special provision, and this debt will have a priority over the rights of an official liquidator in case of a liquidation of a particular company. The third judgment, Pegasus Asset Reconstruction Limited versus Haryana Concast Limited, AAR 2016 Supreme Court, page 494. Pegasus Asset Reconstruction Private Limited versus Haryana Concast Limited, 2016 AAR Supreme Court, page 494. That is a case of a dispute in respect of companies under the Companies Act and the Surface Act. Whether the provisions of the Companies Act will have a priority over the Surface Act by the creditors. The court came to a conclusion that the provisions of the Companies Act will not have any priority over the creditors who have moved the Surface Act. It was all an interpretation of the two statutes. And the court found that the Surface Act is on behalf of the creditors, and whereas under the Companies Act it is not so, and therefore it should have a priority over the other debts. The last case before I round up, Ahmedabad Municipal Corporation versus Haji Abdul Kapoor. Ahmedabad Municipal Corporation versus Haji Abdul Kapoor, AAR 1971 Supreme Court, page 1201. AAR 1971 Supreme Court, page 1201. There is a case of a claim made by the municipal corporation that there is a due of a municipal tax. This municipal tax was due for almost 10 years. Municipal corporation slept over its right. Subsequently, it woke up from its slumber and made a claim that we have got a priority because it is a municipal tax against the auction purchaser who has purchased the property brought in an auction by the court. The court found that it was a case originally Bombay Provincial Municipal Corporation Act, which was applied to Ahmedabad at that point of time. It only creates a charge, but it does not have a mechanism to enforce a charge or speaks about a priority of the charge. And therefore, it has held that the tax raised by the municipal corporation cannot have a priority, and an auction purchaser cannot be made liable as though there was a charge. What this sovereign debt and the right of a private person are concerned is that there can be a distinction. If it is purely a sovereign debt, then it will have a priority over everything else. On the other hand, if the debt is contemplated, or the right of the party, namely the government, is contemplated under a particular statute, say for example, municipal tax, right under the Municipal Act or an EPF Act, one has to see the particular act to find out whether there was charge was created or not, and whether there was an enforceable mechanism or not, as we have found in Employees Fraud and Fund case versus liquidator of SK Pharmaceuticals. We have to see whether the act contemplates. If the act contemplates, then we can say the legislature have contemplated that any debt covering under that act will priority over everything else, then that it will have a priority. If the act does not, special act does not contemplate such a thing, then mechanically we cannot say that even if the dues of the sovereign, like the tax, is raised subsequent to the transfer of the property either by auction or by a private sale, then also the it is not automatic. One has to see whether any right is created to the sovereign or a arm of the sovereign, like the municipal corporation or a municipal board or any other board for that matter. Therefore, to sum up, a charge is always subject to section 52, namely the law of least pendants. Two, charge can be created either by act of parties or by operation of law. Three, the operation of law is not does not take within itself a degree of the court. Four, a compromise degree can also create a charge provided the party have got some pre-existing right over it, or otherwise the charge will not operate from the date of the suit, but it will operate only from the date of the degree. 5, in case of an unpaid seller, he has got a charge in respect of the property under section 55(4)(b) of the act in respect of a money to be paid or promise to be paid. And 5, if unless the purchaser improperly declined to take delivery of the property, in case of a refund of money granted by the court in respect of a buyer, he is entitled to a charge. 6, in case of a maintenance, a lady who has got a pre-existing right is entitled to a charge on the property irrespective from the day, and any amount of creation of a third party right will not affect her right. And lastly, the special acts has to be read in conjunction with the common law of charge and to find out whether a charge has been created by the special act or not. I allow me the forum for discussion.
Hello. Yeah. Here we don't have any questions. Since today we didn't, just one question has come. So what is the undertaken of a property in charge and what's the injunction? Attachment and undertaken in charge. How undertaken is equated with an attachment of property?
Undertaking cannot be taken as a attachment of the property. Undertaking is only a personal bond. Namely, if a person did not obey his own undertaking, did not follow his own undertaking, then the law will take its course, namely, to punish the person who has given an undertaking. But that does not mean that the right created by him can be nullified. But if a charge is created or an attachment has been made, then irrespective of any alienation made or a transfer made, then the person who has got a charge can go after the property. The difference is this: in case of an undertaking, the party cannot go after the property. In case of attachment, he can go after the property.
Yeah. That was the only question. Thank you, Mr. Prabhakar. It's always a pleasure hearing you. Thank you.